And immediately here is Charles Cottrell. It says professor, but also former and distinguished president of St. Mary's University. On a personal basis, you know, he's been my teacher, my mentor, and my padrino over the years, and continues to be a person that I count on for sound advice. And you can listen to his interview with Tejano Voices if you want to hear his story. And Ms. Cottrell sitting back, Abby, is another important part of why he's important. She's right there. All right, and then next is Henry Flores. He has been the former dean at St. Mary's. He's also, why he's here, or both of them are here, is because they both historically have been the most important expert witnesses in voting rights cases across the country. And they're going to share responsibility with Henry taking the lead on explaining first, you know, what is an expert witness and why do you have to have them? And then they'll talk about some cases where the nuance begin to change, and then perhaps Charlie might, well, whenever they want to talk about Section 2 and Section 5 and what that means, because we hear this, that Section 2, Section 5, and they got to Section 4, and now we got Section 203, and we're just like, what? Well, don't we just have the Voting Rights Act? So they will try to explain what this means in layman's terms, because everyone basically, but Charlie up here are attorneys. But we'll try to explain what we're talking about. So Henry and Charlie are going to talk about expert witnesses. And then Jose Garza is another important litigator with hundreds of cases and currently involved in the Texas voter ID case. Similar legacy of involvement. They'll be talking about the trial experience, what it takes to bring up the cases, citing cases, and hopefully between him and the next person, George Corvo, who also has hundreds of cases behind them and experienced voting rights cases, maybe they'll find a little area there to tell us why we lost some. Because it's very important sometimes to understand why we can't make a case or why we lose a case. And the one I think of, George, is the one we did in Uvalde, where we had all the perfect scenario with a Spanish surname judge. We had all these important facts, and the judge said, "No, you all just haven't tried." In essence, that's why we lost, and that's exactly one of the elements. You have to try and lose, but he thought we hadn't tried enough. You got to run and lose to show polarization and so on. So maybe Jose and George, in your comments, you'll add one or two examples of why we lose. And now, toward the end of the conversation, hopefully all of us will join in. Say, okay, so now we have these problems with the SCOTUS, the Supreme Court of the United States, changing and gutting the Voting Rights Act and continuing to march in that direction. What do we have for the future here? So we are now officially on time and starting, so that's the end of my participation, and we'll start with, I guess, Henry, you want to take the lead on the expert witnesses?
Okay. This is dangerous, making me the lead. The point guy in Vietnam always got knocked off early. So I'm a little bit paranoid here, and particularly in this company. I'm the junior member of all this group. These are the guys who, one at a voting rights conference here in San Antonio, probably 20, 25 years ago. I was on a panel with Lanny Guinier, and I was about to make my comments, and she stopped me and she said, "Can I introduce somebody to everybody before you start your comment?" I said, she was the moderator. I said, "Of course, you know." And so she said, "The person who just walked into the room, this is in the grand ballroom at the Menger, I guess it was, I want to recognize the person who just walked in the room. It's Dr. Charles Cottrell of St. Mary's University. He is considered the granddaddy of litigation research. This is the man who invented the methodology of kind of expert witnessing. So I'm kind of humbled being here, and these guys, between those two, I don't know, what, 300 cases, 400 cases?
I've only done 2 or 3.
You've only done 2 or 3, but he's done 2 or 3 more, you know. And George and Jose actually taught me to be an expert witness, and so I learned the technicalities of all these kinds of things. An expert witness.
I'm going to interrupt you because I have a very important guest to introduce.
Oh, good. There he is. There he is. Okay.
Joaquin, we're over here. Stop looking at the camera. But we can see you, Mr. Avila. Can you hear us? Hello?
I can hear you.
Wonderful. Can you speak up a little bit?
Yeah, I can hear you.
There you go.
Well, good. I hope that we can hear him. We're starting the panel. We thank you for participating with us. If you can see us, you see who's up here. We got Charlie Cottrell, we got Henry Flores, Jose Garza, and George Corbel. And in the audience, we've got Vilo Martinez, we got Al Kaufman, we got Richard Avena. A lot of the cronies, you know. Said
You
what?
want to get centered in the camera?
The camera's on. We can see you.
Yeah.
Except you're not looking at us. You're looking at the camera. If you will just face forward, we'll get a frontal. There we go. Well, face any way you want to. Just start talking about your experience.
That's perfect.
There you go.
There you go. There you go. Hey, there you go. That's the way to go. You've already been introduced, so we can get to the subject. What was it like to do all these cases early on?
Terrific.
Wonderful. Tell us why.
Well, that's what I was going to tell you. Do I start now or what?
Yes. Start now.
Okay, because of my stroke, I can't speak extemporaneously, so I have to speak from prepared notes. So here I go. I'm pleased to be here with so many of the people who played a critical role in my development as a voting rights attorney. I wish I could be there in person, but my recovery from my stroke in 2010 is not complete. Before beginning, I want to publicly thank many of the persons who played a critical role in my development as a voting rights attorney and who made me here at the conference. First, there is Vilma Martinez, who hired me to work at MALDIP as a staff attorney. Sanford J. Rosen, MALDIP litigation director, who assigned me my first voting rights case in Southern California in 1974. George Corbel, who took the time and had the patience to teach me how numbered plate systems had a discriminatory effect on Chicano voting strength. I can assure you that was no easy task. So thank you, George. Charles Cottrell, who worked on the white versus register case as a primary and expert witness, and who taught me about the factual complexity involved in voting dilution cases. Henry Flores, who provided the intellectual evidentiary underpinning for many of our voting rights cases. Jose Garza, whom I first hired as a law clerk at MALDEP, and later became a stellar voting rights advocate for our community. I want to publicly thank Jose for his great razor-sharp mind that kept my thinking and legal arguments on the up and up. I also want to thank the numerous Chicano communities and individuals that instilled in me a passion for voting rights that is both wide and deep, and that have lasted for over 40 years until this very day. I remember the numerous meetings in places like San Marcos, where we drafted our proposed redistricting plan for the county commissioner precincts that was ultimately adopted. I will never forget how we spent hours using census data and calculators looking for one person. I'm happy to report that after 2 bottles of white wine, we found the one person. Our discovery, of course, led to numerous congratulatory toasts. And I also want to thank community activists like Rosalie Castro and numerous others who provided me through their strongly held personal commitments to politically empower the Chicano community, a sense of deeply held convictions that served to solidify my convictions. My thanks also to the Chicano communities in Beeville, Alice, Corpus Christi, Dallas, Sanderson, and of course, Rock Springs, where I was told to leave town before sundown, and also the towns of Sanderson, Pecos, Van Horn, and the city of El Paso. Finally, I want to recognize the important contribution that my compadre, the late William Velasquez, then Executive Director of the Southwest Voter Registration and Education Fund on my professional development, and who most importantly introduced me to the historic drinking establishment along the Riverwalk, the Esquire Bar, where many of our plans were hatched over a series of cold beers. In a short period of time, I want to make several points, but because of the time constraints, I can only make one. I want to focus on the law students, and especially the 1Ls, if they're out there, and express my most profound plea for you to serve as our next generation of voting rights attorneys. We need you to continue the fight against Chicano voting discrimination that began shortly after the Mexican-American War and continued well into the 1960s and the present. We need elected officials who are going to be responsive to our community's need to be left alone. We need elected officials to fight against the wrath of the majority as the government engages in massive deportations. This wrath will be directed toward our communities by both Republican and Democratic administrations. We are living in dangerous times where close to a majority of Republicans believe that Donald Trump best represents their views on immigration. When else, we need you. We need you to continue the fine tradition that was first set by attorneys like Mario Obledo, George Corbel, David Richards, Don Gladden, Betsy Julian, and the TRLA attorneys in Northern Texas, Jose Garza and Ina Perales as well. We need to continue the fight and win the future battles to provide a political voice to our community. I contend that the Latino community is at the forefront of enforcing voting rights more so than any other group in the country. I contend that Latinos have filed more Section 5 enforcement actions than Section 2 actions in the country. A review of voting rights cases filed through the PACER site will demonstrate that. In fact, I am not aware of any attorney that has filed more voting rights cases than Rolando Rios out of San Antonio, about a couple of hundred or so, or Jose Garza and Ina Perales. I only have about 60 or so cases as provided in my list of cases, which I will provide to Jose Garza for distribution. The major point I want to make is that in Texas, Jose Garza, Willie Velasquez, and Rolando Rios and I adopted the only systematic, comprehensive approach towards voting rights enforcement than any other organization, even the voting section of the Department of Justice. This Texas approach was first created in the 1970s when Billy Velasquez and I on numerous occasions quenched our thirst at the Esquire Bar in San Antonio down on the Riverwalk. It was further refined to the balconies of the Esquire Bar in discussions with Jose Garza and Rolando Rios. Basically, what we did was to focus on the major problems confronting Chicano political empowerment at the time. There were two at-large elections and gerrymandered commissioner precincts or districts. With respect to county commissioner precincts, we had a little noticed bonanza, the state political geography. First, there were a large number of counties, 254, and many of them were severely underrepresented, and there were few, if any, elected Chicano county commissioners. And each county required election by district, hence the commissioner's precinct. After White versus Register, a major constitutional challenge, which for the first time in history held a multi-member or at-large elections for legislative districts in several counties in Texas were unconstitutional. We sought to apply the holding to redistricting. Register was factually a very complicated case. In fact, I remember Charlie Cottrell, a major expert witness in the case, stating that the attorney has set the evidentiary bar too high. I invite you to look at the district court decision in Gray versus Barnes for you to see the factual complexity. For example, the plaintiff's attorney, most notably George Corbel, looked at the location of racially restrictive covenants in San Antonio that excluded Mexican Americans from owning homes in certain parts of San Antonio. For those of you who live in San Antonio and own a house, you should read your deed. I bet you will find a racially exclusive restrictive covenant. Shelley v. Kramer merely outlawed the enforcement of these covenants in state court and effectively invalidated them, but did not require them to be stricken from the existing deeds. I remember a discussion I had with Charlie Cottrell. Basically, Charlie said that it would be difficult to replicate the White versus Register evidentiary presentations in other cases, either because it was not there or because of the prohibitive cost. It took me 10 years to fully appreciate that prescient observation by Charlie when I worked at Malden and filed a successful at-large election challenge against the Corpus Christi Independent School District. Back to the county commissioner courts. We had a survey based on the 1970 census that showed that there were at least 125 counties that had a 25% Chicano population, and there was Chicano underrepresentation on the commissioner's court. So we decided to focus on the commissioner's precinct. Our review of the redistricting showed that the Chicano communities were either fragmented or over-concentrated. that there was an opportunity to make changes using white versus registered to challenge these redistricting. Subsequent cases applied the white vote dilution legal theory to challenges to redistricting plans as well. But using the white approach was too burdensome and too time consuming. But there was another approach that was more efficient, using the one person, one vote principle at the liability part of the case and Section 5 at the remedy portion of the case. By using the one person vote principle, all we had to show was that there was a numerical population deviation from an ideally populated district. There was another advantage in Texas. Many of the counties had not redistricted for decades, so they were severely malapportioned, which made our case at the liability phase more compelling. This approach was simple to do and much easier than the white versus register approach. After we secured a ruling that the plan was unconstitutional, then we used the benefit of Section 5 at the remedy phase. Any new redistricting plan had to be submitted for Section 5 review. This important holding was reaffirmed in an important districting challenge filed by TRLA against Clever County that reached the Supreme Court. As the result of this holding in Sanchez versus McDaniel, the new plan had to be submitted for Section 5 review, where the burden of proof was reversed and the defendant had to demonstrate that the new districting plan did not discriminate against minority voting strength and was not adopted pursuant to discriminatory purpose. Without Section 5, the plaintiff would have the burden of demonstrating that the new plan was unconstitutional, a more difficult burden. As a result of this aggressive approach, we changed the political representation of county commissioner courts throughout Texas. We were successful in securing many Section 5 letters of objection against Texas County. I am not aware of any other attorneys or civil rights organizations outside of Texas that use this approach in a comprehensive, systematic way to challenge discriminatory districting plans. I am here to announce that there is still plenty of work to do. We need law students to help write law review articles. First, we must distinguish the Shelby County case and reinstitute Section 5. In my view, Shelby County only invalidated the triggering formula of 2006, not the previous coverage formula. Under the previous coverage formula, with the exception of the 1982 amendments, there were no sunset provisions. Thus, under the previous coverage formula, the only way to exempt a jurisdiction from Section 5 was the filing of a bailout lawsuit. Accordingly, unless there is specific language including all of the 1975 coverage formula, the 75 coverage formula is still intact. It is a complex argument that involves a careful and detailed review of the public laws enacting the 75 and 2006 amendments. I contend that the 75 coverage formula is still valid and Section 5 is still alive and well. I'm not aware of anyone else making this argument. I could be wrong about this argument, and I assure you that I was in a complete sober state of mind when I thought about this approach. Second, with respect to a new VRA, we should be thinking outside the box and have a targeted bail-in lawsuit approach, where a plaintiff could sue to have a jurisdiction covered under Section 5. Presently, we can only do that under Section 3. But the problem is that it has to be brought within the context of a Section 2 case or a constitutional challenge, which can be very expensive. Instead, under my approach, we just proved to the court the existence of racially polarized voting. If successful as to prove, then the court could impose a Section 5 clearance requirement. I favor this targeted approach rather than the blanket coverage approach, which raised federalism concerns to the majority of the Shelby County decision. There may be other approaches, but we have to try a different approach rather than the blanket coverage proposals under consideration in DC by individuals who have never filed a voting rights case, much less filed a voting rights case in a private attorney capacity. A final suggestion is that we should have a state voting rights act in Texas, modeled after the California Voting Rights Act, that will facilitate challenges at large in state courts. I want to publicly thank George for his insight. I spoke to him one time at a conference out in DC, and we talked about the CVRA language that was being proposed, and he made some excellent suggestions regarding the totality of circumstances and how that should be taken out, which we did. The California Act has been very successful in eliminating discriminatory at-large methods of election. It has affected either through litigation or voluntary conversion over 100 jurisdictions. We are trying to have a similar act implemented in the state of California then Colorado, then Texas, and finally in Arizona. There was a proposal being considered by the Washington State Legislature and a voting rights coalition. The result was a disaster and a dangerous bill that would require plaintiffs to effectively prove their case to the jurisdiction before the filing of any case. First of all, it would give the jurisdiction a period of years to voluntarily change before a lawsuit can be filed. If you're going to work on the State Voting Rights Act bill in Texas, I would simply borrow the language from the California Act, and under no circumstances should you use the Washington State law. It is a dangerous piece of legislation. The final point I want to make is that we need law students to work with me and my research assistant, Molly Matter, to develop law review articles which we can all co-author. Given today's technology, we can do this long distance. We need to get these new ideas published so they can be part of the new reconstruction. According to my count, we are in the middle of the fourth reconstruction. We all know about how the first reconstruction turned out. The second reconstruction started out with Brown versus Board of Education decision, and then fizzled out after reactionary rulings by the U.S. Supreme Court. The third reconstruction began in Texas in the 1970s with the White versus Legislature case, and when Willie, Rolando Jose, Garland, George Corbel, and I filed redistricting challenges in the 70s and 80s. The fourth reconstruction started with the adoption of the California Voting Rights Act and involved the current efforts to fight discriminatory features between plans at the congressional and state legislative level in Texas. At large elections, English-only elections, and obstacles that hinder voter registration and voter turnout. We need law students to help us continue with this new reconstruction and tradition. With your help, we can do it. I am here to also announce that we are not going to give up. We don't have the luxury of giving up. We need you, law students, part of an army that will restore the right to a meaningful vote in our community. Come join us, the voting rights attorney present at this conference, me and Molly Matter, my research assistant at Seattle School of Law, and be part of this movement that is making a difference. My email address is very simple, avilaj@seattleu.edu, and my cell number is, my office number is 206-724-3731. That's 206-724-3731. Jose Aga has all that information. I prefer email. As Machete once said, Machete doesn't text, and neither do I. And because I'm not a twit, I don't Twitter. You have a front upcoming battle. Gracias.
Thank you, Joaquin. You're welcome to stay on, and I think you can see the panel, can you not?
I can see you guys.
All right, well, you can hear them talk next. Henry Flores is going to follow you up. You're welcome to stay there. The audience would love to keep seeing you. So, Henry, you were discussing the expert witness. What is the expert? Why is it necessary? How do you become one? And what do you say when you're the expert?
My gosh, you say what the attorneys want you to say. No,
Which is?
No, it's Joaquin was really good because he brought out all the things that the expert kind of gets involved in. You know, the lawyers present the legal theories and the law and argue the law and create the trial and present the case, and they're the real people behind things. The experts themselves are generally academics for the most part. As far as I know, in voting rights cases, we're all PhDs. I don't know if there's one, there's not. Occasionally, George will act as an expert because George acts as an expert in the actual technical drawing of congressional districts because he really knows how to do that stuff very, very well. He's been doing it for a long, long time. So, for the most part, what we do is do the research that generates the evidence required to meet the standards that the Voting Rights Act itself has set forth in the various sections of the Act, that the lawyers then organize in the legal argument and present before the case. We get brought in. Angel said, well, what do you need to do to be an expert witness? Well, the way I became one was Charlie decided to retire and turn my name into George, and George called me up and said he's going to pick me up and drive me over to someplace and we're going to do a case. And then Jose intervened and said, no, I need you for a TRO in the remember the San Antonio River Authority, where I opened my big mouth and said the wrong thing, and he had to come rescue me on the stand. It was very funny. His eyes just went like, oh, what did he do? But essentially, so we have to have research skills for the most part that we pick up in our PhD training. Most of us have backgrounds in statistics. Some of us have backgrounds in the use of GIS software, and of course all the different sorts of sophisticated academic software, SPSS, the statistical package for the social sciences. Sometimes they use SAS, which is another one. And sometimes we use EI, which is a very, I don't even want to get into what it is, but it's really a maximum likelihood estimator of multiple variables that go, see what I mean? You need the training to take this stuff on, and some will write the actual programs in R software. Why do we do that? Because the two areas of the Voting Rights Act that we really get involved in are the proving the three prongs of Section 2, and you heard Joaquin talk about Section 2, Section 3, Section 4F, and Section 5. Those are various important parts of the Voting Rights Act, and we get involved generally in Section 2 and 3, Sections 2 and 5. And Section 2 is a way for a plaintiff to sue a jurisdiction after the damage has been done. A law has been put into effect that people think may be in violation of the Voting Rights Act, or may be in violation of the 14th Amendment, or some other sort of law, and Section 2 sets the standards for the presentation of the evidence. It's got three elements in it, and the first element is that you've got to show the court that you can actually draw majority-minority districts, Latino majority districts, African-American majority districts, whatever the case might be. The second one is if you've got to present evidence that the populations, the voters, vote in a racially polarized manner, which means that simply you have to show statistical evidence over a long period of time that, for instance, Latinos all vote predominantly one way and opposite from Anglos in the same elections. So you have to present a series of elections and show the statistical estimation of what the percentage of votes for the Latinos are in every one of those elections. And sometimes you have to explain the technique to the judge. So I think I'm one of the few experts that's ever discussed the regression analysis verbally, the entire equation. One attorney for the other side asked me one day in a deposition, he said, well, Dr. Flores, what is the regression equation? And I said, okay. So I recited the regression equation. For some reason or other, the night before, I felt I had to memorize it. And I did, and I recited it. And someplace in one of the, in a deposition of a case, all discussed the entire regression equation, verbally stated. And so you have to know what that is and how the algorithm works, and to be able to present it to the case. The third element is you got to show that Anglos vote consistently as a bloc to overcome the votes of the Latino voters within the jurisdiction that you're looking at. That's another whole series of elections that you look at. You use a statistical analysis to do the same thing, and you present that, and then the attorneys take that evidence and they present you in court. They question you. They take you through the whole thing, and then you're off, and they've got their evidence in the record, which then they argue the legal philosophy of the whole thing. The other section is the most powerful section that we have is Section 5. It used to be the pre-clearance. No, it's known as a pre-clearance section. A jurisdiction that's under coverage of the Voting Rights Act, and there's only specific. Section 2 applies to the entire country. Section 5 only applies to certain jurisdictions that the Congress of the United States has deemed has had a historical record of discrimination, and they're enumerated in the VRA. You can find the list there. It was important, and it was the most powerful part of the Voting Rights Act because it was pre-clearance. Before any one of those jurisdictions in question could submit any election change, moving a poll, changing a district's configuration, changing an election day, whatever. They had to send the change to the Department of Justice for pre-clearance to ensure, and the Justice Department would, Peyton McCrary deep down in the bowels of the Justice Department would look at it and say, okay, it's fine or it's not fine. And then they'd notify the jurisdiction, you can implement it, and it would go forth. No trial, no expenses. A Section 2 case will cost as much as $2.5 million to put up. And if a plaintiff, a poor plaintiff, a Latino plaintiff has got $2 million, $2.5 million to challenge a jurisdiction, well, if there is a God, bless him, because that takes a lot of money. A Section 5 case is a lot less expensive and doesn't require a trial, and a lawyer can just bring it up and say, hey, Nina Perales one day actually called Bexar County when they were going to shut down San Antonio, when they were going to shut down an early voting site on the east side of San Antonio. She saw it announced in the newspaper. She just called the elections department and said, hey, you want to get sued? Don't put that in. And they didn't. They kept it open. You know, they tried to argue that there were too few voters, it was costing the county too much money, and she said that doesn't make any difference. That's a historically black voting place. The community's used to it. You cannot shut this down. And that was the end of that. So Section 5 was really, really important. I don't know if I need to go through Shelby County on all of that sort of stuff. I think I might let you guys deal with the Section 4F. Section 5 is triggered by what was in Section 4F, which was ruled unconstitutional. No, not unconstitutional, out of date, really, by the Supreme Court. And in the Shelby County v. Holder case that was heard in 2012, I think it was, or decided in 2012. And so Section 5 still stands in there, but it has no triggering device at this particular moment. And the Congress, I guess what's in Congress right now, I haven't been following it in great detail, is supposed to try to rectify that situation. Why do you need one of us? To legitimate the case. We bring credentials, we bring expertise, we bring the academy, the intellectuality to the case. So on one level, it legitimates the data for the court, and that's what the judges want to see. They want to see a legitimate presentation of hard evidence in the case before they decide it. Most importantly, though, Judge Tatel asked me in the Section 5 pre-clearance hearing in the D.C. Circuit. He asked me, I mentioned it in another panel briefly, and some of you may have heard this already, but I'll just repeat it for everybody else's benefit. As I was getting ready to leave, the judge asked me, he said, Dr. Flores, why is it important for us to hear your testimony? And it struck me like, I almost went into a panic, like I hadn't thought of that question before, and I couldn't ask for help. Like, you're on the stand, the expert, you're on the stand, and you can't go turn to the attorney and say, what do I say now? You can't do that. You have to show your expertise and answer the question. And I thought about it for a second, and I turned to the judge and I said, Your Honor, you look at the case as a lawyer and a federal judge, and so that's one perspective. You look at the case through those kind of lenses. I look at the case through the lenses of a Chicano political scientist. So I look at the case from the way my community would view this particular situation. And then I give you that story to go with your perception. And I think that helps complete the picture for you, for your benefit. And so I think that's why my testimony is important here. And he said, okay, thank you, and I left. Later, a law student from American University actually told me that's the first time that she had ever heard Chicano studies used as an expert witness tool in a voting rights case. Because that's exactly, I approached it from a Chicano studies point of view. As a Chicano political scientist, not a political scientist. That's the first time I'd ever done anything like that. And I think that's really, really important, and something to think about down the line. One thing that's interesting about all of this, though, is that The times for experts have evolved over the years. As technology has evolved, the way we approach a case evolves. The experts become more and more narrowly tailored. We become narrowly tailored experts. So until this last congressional redistricting lawsuit that still has no opinion, no decision, I was known as a Section 2 expert. And that's what I got hired to do. We get paid. A Section 2 expert. And when Nina called me up, Nina Perales from Maldiv called me up, and I said, you already have Dick Engstrom and you got Morgan Kauser, who are Section 2 experts. Why do you want me? And she said, no, you're not going to do that. You're going to be my racial intent expert. And I said, I went into a panic because there is no such thing. And the whole area of racial intent had really never been looked at by an expert or testimony presented in any kind of trial yet. And we had little hint about what it would be. Actually, it was a big footnote. And I took the footnote, worked around that, and I trained myself to be a racial intent expert. So that's what I do now. That's what I write on, and that's the research that I've been doing. I have one book on it already, and I'm working on a second book that's really lending some depth to it at this particular point. But anyway, that's what an expert does, and from my perspective, anyway.
Charlie, would you tell us about, all right. Tell us about that pioneer work. The first time the phone call comes, you're going to do the register case, the Whiteley register case. Tell us about that experience and how you had to prepare to become that first expert witness.
Well, I want to thank you. I want to thank you and thank CMOS for having us here. This intergenerational discussion is really important, I think. I'm a historical bookend that almost hadn't fallen off the end of the table yet, but we wanted to lead with Henry because Henry and Jose and George will really give you where we are. I don't want to confuse too much of this with what was rather than what should be and what we'll go forth with. I want to also acknowledge that I'm actually the student of these folks, all of them. Henry more recently in terms of all the work he's done, Jose and George and Al Kaufman and many others. Vilma enjoyed working in White versus Register when Maldeff was 4 years old at that time. It was an infant, but what a grown-up it has become. Just this point, White versus Register was prior to the Voting Rights Act, but had shaped a lot of what ultimately was given in testimony for the Voting Rights Act. And you know the act itself had covered the Deep South since 1965. It was extended to Texas and to language minorities and some other parts of the U.S. in 1975. George taught me so much about in the White v. Register case, which basically challenged at-large election districts in Dallas County and in Bexar County. And Dallas County was in some senses easier to show because it was such a stark issue of black and white. There had been Latinos elected, a very few, in Bexar County. And so what we developed, and as a political scientist who didn't know much about expert witnessing, you look to whatever you have. And what is significant is that we didn't have anything. We had a book on the place system, and we had a lot of people's stories. We did not have the kind of research. We didn't have a book like the one Henry has here that he's just finished and completed on Latinos and the Voting Rights Act. My goodness, that would be so extraordinary to have had something like that. So I don't want lightning to strike here, but I went to European political parties and a person by the name of Maurice Duverger, who basically talked about the ways in which, it's common sense, the ways in which the rules of the game affect the behavior of the outcomes. So if you have an at-large election system and you have racially polarized voting, and you have a numerical minority of Latinos, then obviously, if there is racially polarized voting, guess who's going to win that election if you structure it that way? The difficulty was to distinguish that point from the fact that this was all mixed up in partisan politics, Democrats, Republicans, and Latinos vote this way, and so on. So the long and the short of it is, on that story, is that we were able to convince Leon Jaworski in the state. He chose not to cross-examine. George noted that right away. He, I think, cheered that, cross-examine on that point, showing that basically an election structure, a set of rules, can affect the outcome of what happens. So Byron Whizzer White, Justice White, Marsh, and a few others on the Supreme Court picked that up, and it was difficult to understand. When we tried subsequent cases, I was going down to Galveston County with David Richards, and I really enjoyed David a lot. He had his straw hat on, and he said, explain that to me again, the way that works, the way these systems work. Well, everyone knows now that single-member districts representing people and who vote a certain way give people the ability to have the preferences of their votes recognized. That's what it's about. And from that, not always, but from that should come some kind of representation that brings about people's lives, makes them better. The kind of services they receive, the kind of streets and curbs and parks and libraries and Jose Uriegas is here, and the kind of economics they have. That should work that way. And it does, it certainly changes when you have single-member districts. San Antonio would be the case in point on that. We then carried that into the voting rights testimony itself, the Voting Rights Act. And here I want to simply reiterate some things that Henry has said and said earlier. For me, this is a simple story. It is a story of, first, of equal citizenship. That is a powerful norm that, to me, guides me enormously in this. It is, secondly, an issue of abject, absolute justice. There's justice involved in this in terms of the access and discrimination and so on that is very, very clear. And finally, that in turn is a question of the dignity of people involved. So the story that is told, that Henry refers to, and that I learned so well from George and Jose and Al and others, you tell a story, and the story is a people's story. It's a story of, unfortunately, rigidly held in statistics, but it's a story of health, it's a story of the economy, it's a story of families, it's a story of the way in which they live. So in the 25 years I did this, the expert had a broader view than what's happened now. The expert was really the person who could help tell that story with the questions from the attorney. Mm-hmm. And the story, of course, I pay so much tribute to the people here and those in the audience, but the story itself, its context comes from the people. It comes from the interviews you do, their lives. So we're talking about Texas here, but my own life led me into Selma, Alabama, Mobile, Alabama, Shreveport, Louisiana, the Navajo Nation, Los Angeles, initially Yakima Valley, we never finished that one, Boston. It led me into other places where the Latino and Latina story, it was played out over and over again with these rules of the game. So I was in the case that, and I want to curtail my comments, I was in the case it became City of Mobile, Alabama versus Bolden. If you don't know, it was first Bolden versus City of Mobile, Alabama. I had to learn that it's Mobile. When I said mobile, they said, no, it's Mobile. It's Mobile, Alabama. Mobile, Alabama was a special case. It was the last southern city that slaves were brought in. So Judge Arno was a wonderful judge. Of course, he understood all of it. He took a tour of the city with defendant and plaintiff attorneys and others. And in those days, they would let me speak to the defense witnesses as well. But I couldn't use that in court. And what you hear is really the political story, the sociological story, the cultural story of racism and discrimination. You hear it from the people who are speaking. You hear about their disengagement, the distance, the anguish, the struggle, what they've done over and over again to try and overcome these rules. And then you try and put that into the kind of particulars of statistics that allow you to say what kind of condition of life they have. So it's their story that you're talking about on the stand in those days. And we won every part of that case. James Blackshear and Larry Menifee were great attorneys, and we won everything at the district court level. We won the appellate court level. But then along came something that Henry and George and Jose and Al, everyone is working with now. We were denied at the Supreme Court level on the basis of intent. I can tell you that in Justice White's dissent and Justice Marshall's dissent on Mobile case, that they had it. They said, this shows intent. All of these things, this not listening for decades to the black or to the Latino community and what they were asking for, shows some intent. They went through it very meticulously. And then intent became an issue, and then I want to trail off and say, I didn't take it for granted that if I were before Judge Hawkins in Shreveport, Louisiana, that he would be automatically opposed to me as an expert. But the conservative judiciary then has begun to restrict in other ways. That is an extraordinary issue, that question of intent. And Henry is has a book trying to show us how to look at that. Intent was one thing, and then Section 5 was another. And Henry didn't go into this, but Section 5, through the Voting Rights Act, allowed us to actually engage citizens. That's what's not known about this. We had a voting rights Section 5 project that Rosie Castro, myself, and others worked on for a couple of years. George showed us how to do this. You could actually contact the Justice Department. You could show what these rules meant. You could educate citizens on this. We had a booklet in Spanish and English that Richard Avena and others helped support. And we put together, we'd have community meetings on how to monitor the Voting Rights Act. Well, that's gone. And the conservative judiciary became more and more narrow. And I think, Henry, that we were able to tell our story politically, sociologically, racially, culturally in the days that I was there. But increasingly, it became a statistical match, and Henry is a whiz at statistics. He had to be to stand up to what was happening, and then became a question of basically squeezing the very life, the real life, out of these communities relative to the politics that the people knew. It actually restricted what people could say, what you could say in court, and what was admissible and what wasn't, and so on. So. It's a 50-year recognition of the Voting Rights Act. It was extraordinarily important. It still is very important, and probably the panel which is dealing now with how to enhance the participation in politics is one of the answers, because in my view, the attorneys and the experts today have a very steep hill to climb, not impossible, and certainly one worth climbing. But it's a very steep hill to climb relative to what they face, relative to White versus Register, Graves v. Barnes, and all the other cases that one took part in earlier, where you were able to show statistically, and from the statistics, and from the story, and from the witnesses, you were able to show that intent was there. A final footnote. I was able to interview one of the mayor pro tems in the Bolden case, who was the defense witness, and if you would have heard him speak about the minority community, you would know what I'm talking about on the other side. One is the anguish, the distance, and so on that people who are the plaintiffs feel concerning being excluded for decades. That's one thing. The other, however, is what is actually thought of by this individual from Doniphan, Alabama, moved to Mobile. he said that they had laid on an African-American who was the masseuse at the men's white club in town, and they put him on council. And they said, you know, he's a good old boy. He said, but he's not smart enough. We got to get another blackie. So in being able to talk to people who were on the other side, and not all of them were terrible people, but they had a very clear view of what they were defending. And they had a very clear view of how they were going to defend it. And so we must go forward. I close with what I hope is a hopeful sign. Henry wouldn't say this, but I agree that we are almost pre-1965 when the Voting Rights Act was passed relative to what must be done. And that was done through struggle, through commitment, through political voice, through law. And thank God we've got groups like MALDEF, frankly, today who can at least give us that kind of expertise and that kind of support. I hope I haven't spoken too long. Thank you.
Thank you. Jose, why don't you tell us some of the cases you've tried, ending with the current one on voter ID and then your collaboration with George, so then he can wrap it up. Well, we have some time for the audience later.
Okay. And I think that is actually what I'd like to do. One of the things that upsets me a lot when I talk to people that are involved in the political process is where they talk about, you know, the only reason we lose elections is because Mexican Americans, they don't turn out to vote. Right. They're just not interested in the voting process. You know, that's really hard to take in a place like Texas. Texas is 50th out of 50 states in voter turnout. Texas has the harshest voter registration, voter ID. I mean, everything that the state can think of to do to repress people from voting, especially people of color, they do. In Texas, for example, if you're going to help somebody cast a ballot by mail, you can only help one. If you help two, you have committed a criminal offense. And I know people who have been prosecuted for helping two people cast a ballot by mail. So you have to talk about the things that Charlie raised. There's the structure is what you begin with. And it hasn't been my experience that people in the Mexican American community are disinterested in politics. And I'll give you two examples. In the 1980s, we did a lawsuit against the city of Taft. And for those of you that are from Texas, you know that Taft is just up the coast from Corpus Christi, a little bit inland, but just up the coast. There was an ex-Marine, an ex-Korea veteran, his father, who lived in Taft, Texas. And his name was Miguel Garcia. And in the early 1980s, Miguel would make a trek up to San Antonio, and he would visit the MALDEF office, and he would implore the lawyers at MALDEF office to come help them in Taft with the election system. Taft was almost 50% Hispanic and had never elected a Mexican American to the city council. And every time Miguel would come up, we would say, you know, we're really busy, Miguel. We're doing statewide redistricting in New Mexico. We're doing statewide redistricting in Texas. Vilma Martinez is after us to get into California. We don't have time for little old Taft, which is about 3,000 or 4,000 people. And he would say, yeah, but we don't have any Mexican Americans on the city council. We don't have any parks on our side of town. Why don't you come down and visit us? And we say, as soon as we get a break, Miguel, I promise we'll go down and visit you. He made this trip up like 3 times in that year. And then the last time he came up, he said, you know, I just talked to LULAC. And LULAC said, you know, put it on the agenda for the city council and get one of those MALDEF lawyers to come down and tell them what's going to happen if they don't go to a district form of election, and you might win. And so I said, okay, Miguel, we'll do that. You get it put on the agenda, you get somebody on the city council that will do a motion to change the election system, and we'll send a lawyer down to help out. And he did, and he called us and he said, it's on the agenda, send somebody down. I had one of the lawyers in the MALDEF office, his name was Jose Roberto Juarez, a wonderful
Beto.
young man who now teaches at the University of Denver Law School, I believe.
Yeah.
Anyway, and was dean of the law school for a while, I think. Anyway, so Beto comes to my office, and I said, okay, these are what you need to do. You need to go down there, and you need to tell them all the advantages of single-member districts. Tell them what it's going to cost if they don't go to single-member districts, et cetera, et cetera. Do not tell them we're going to sue. We can't sue. We don't have the resources to do it. We're too overextended. So Beto goes to Taft, and he's surprised by the reception he gets. He walks into a fairly small city hall, and it's packed, and it's hot. And on one side of the room, it's all whites, all Anglos. On the other side of the room, it's all Mexican Americans. There isn't any cross between the two of them. And they get to the point on the agenda where they're going to consider going to single-member districts. And they call on Beto to come and make his presentation. He goes up, and he's very calm. Then he starts hearing it from the Anglo side of town, on the Anglo side of the room. Why don't you go back where you came from? You're outside agitator. And Beto is from Laredo, and it's 90%, 95%, 99% Hispanic. He'd never experienced this one-on-one like this, and he kept getting hotter and hotter at the podium, and he finally said, it's easy. Go to single-member districts or we're going to sue you.
I can see Beto doing it.
So, of course, there are a couple of the councilmen that are afraid of a MALDEF lawsuit. And they do a motion to go to single-member district, and it loses 3-2. So Beto comes back and he says, you know, I have some bad news and some worse news. And I said, okay, what is it? He said, well, it was close. We lost by 1 vote. We're going to sue. So we did file a lawsuit, and you know, as they described, these lawsuits, the Section 2 at-large election challenges are very fact-intensive. So we went down and we looked at the deed records. It turns out that the city of Taft in 1984 ran a cemetery, and the cemetery was segregated. City-run, segregated cemetery. Deed records show that the cemetery was, the property on where the cemetery was deeded to them by the Ku Klux Klan. And in the deed it said, this is where Mexicans are buried, this is where whites are buried, this is where Negroes are buried. And so we went down there and we walked the cemetery. And sure enough, on one side of the cemetery, it was what we call in Texas carpet grass. It was very well manicured. I mean, it was pristine. And you walk across a caliche road and it's overrun with weeds, and they're only Spanish surnamed headstones. And then there's a dirt road, and there are crucitas, and that's where the African Americans in the city of Taft were buried. But it was more than that. We found, for example, that there was a health clinic that was run by the city, and the doctor imposed a segregated waiting room in 1984. Whites here, blacks and Mexican Americans over here. We got the most conservative judge at that time in Texas. Today he'd be a moderate. But at that time he was the most conservative judge in Texas. Hayden Head Jr. was our judge. And we went to trial. We went in for what's called a preliminary injunction. And Bob Brischetto was our expert on because we could get him cheap. He worked for Southwest Voter, and Southwest Voter paid his fees, and he did our racially polarized voting analysis. And we got the mayor on the stand, and we got him to explain how they ran the city cemetery. We don't really segregate. It's just that it costs more to get buried over here, and the Mexican Americans don't want to pay the extra $50. That was his explanation. And oh, by the way, the reason you see all those weeds and everything is because it had just rained, and we couldn't get the mowers in there. So, of course, the Polaroids that we took showed that the roads were dry. There was no standing water. It hadn't rained. That's just the way they kept it. So we put on what we thought was a very good case. Unfortunately, we lost at the preliminary injunction, and Judge Head wrote this opinion, and he said, we don't have to prove intent anymore. Remember that, because of the amendments to the Voting Rights Act. But he said Your racially polarized voting evidence just shows that Mexican Americans vote one way and Anglos vote the other, but you don't tell us why. It could be that it's because the polling place is too far over here, or it could be because of religion, or it could be because of politics. So go back and do some more research, and maybe, you know, we'll have a different result. So the reason I tell this story is because it has sort of that fascinating local evidence, right? But it also tells the story of the Mexican-American community, because Miguel, shortly after the preliminary injunction hearing, we actually won the case eventually, but before that, Miguel was diagnosed with bone cancer, and he had to go have a bone marrow transplant in Seattle. And his wife called me right before he went into surgery and said, Miguel told me that no matter what happens up here in Seattle, you've got to do this fight. You've got to do this lawsuit. You've got to take it to the end. Unfortunately, Miguel didn't make it. He died on the operating table, which was really sort of astounding to all of us, because on the day we went in for the preliminary injunction, for example, Miguel was a sturdy, well-built man. After I'd done the cross-examination on the city manager, he came out and he gave me this huge hug and he said, "You did a great job." And think about the persistence of coming every day up to San Antonio, driving all the way from Taft, over and over and over again during that span of period, to push MALDEF to get involved in this thing because it was so important. And telling us about, look, drive through Taft. On the Mexican-American side of town, you will see the ditches run through the front of the house, and those things are never mowed by the city. They always flood. Go look at the Anglo side of town. They have this concrete drainage system. They never have any flooding. Go find where the parks are. They're on the other side of the highway. Go see where the sidewalks are. They're on the other side of the highway. In fact, when we cross-examined the city manager about the sidewalks, I asked him, "Have you ever applied for a federal grant for this?" "No, we don't believe in that." So that's Miguel's story. Then there's the story of Gonzales Independent School District. 7 districts elected at large. The community is about 27% Mexican American. There's a case that MALDEF did together with Coastal Bend, at that time, Coastal Bend Legal Services. Joaquin assigned me to that case to work with the lawyers from Coastal Bend. There'd never been a Mexican American that had ever run for the city council, for the school board in Gonzales. So we were going to have a hard time proving our case. We initially filed it with 5 plaintiffs. 4 of them were Mexican American businessmen from the Gonzales area, and one of them was a Mexican American grandmother. The day we filed the lawsuit, I don't know if Coastal Bend didn't talk to our clients sufficiently to tell them, you know, what to expect, because it wasn't MALDEF's fault. But 4 of those 5 plaintiffs repudiated the lawsuit, said they'd never authorized the lawsuit, but Eloisa Garza, the grandmother, stuck with us. We went to trial on that case. Eloisa held on. We went to trial. We had Dr. Fred Cervantes was our expert from Corpus Christi. We didn't have a lot of statistical evidence, so we had to go, you know, based on the culture, the separation of the communities. He did a wonderful job of presenting the picture. At closing arguments, after we presented all our evidence, I made the presentation for the plaintiffs, and then the lawyer for the school district gets up, and he looks at the judge. This may have won the case for us. He looks at the judge, and he's going through the different legal standards, and then he stops and he says, "Look, things are different in the Gonzales Independent School District. We lost 5 of our boys at the Alamo." And he sits down, and Judge Fred Shannon is our judge, and Generally, when these cases are over, the judges take them on what's called under advisement, and you don't hear anything for months, and then they come in with, or in the case of the state redistricting case, years.
Years, yeah.
But he came back immediately, and he said, I'm ready to rule. I find that the at-large election system in the Gonzales Independent School District discriminates against Mexican Americans. But in fact, it discriminates against everybody. It discriminates against liberals, it discriminates against conservatives, it discriminates against everybody. You need to change the election system. And he looks over and he said, and he asked me, Mr. Garza, what are my options here? And I said, well, you have to let the school district make the first offer of a remedy. But you can put restrictions on that. Like, for example, what? You can tell them to draw a plan of 7 single-member districts. And he says, well, that's what I'm going to do. You have to draw 7 single-member districts and present it to the court, whatever. The lawyers for the superintendent walks over to us at the close of the trial, and he says, we've just fired our lawyer. Will you draw the districts? But this story is really, I mean, we can talk about, and I am humbled to be in the presence of such giants. Vilma once sent me a birthday present that said, short people arise. and I needed that, standing with these giants all around me. But it's the persistence and the tenacity and the involvement of the Mexican-American community. I think that's the reason we all are involved in this kind of work.
Thank you. George, you want to wrap it up in about 15 minutes so we have time for the audience?
It won't take that long. First of all, I would like to recognize some people. Richard Avena over here, that was the head of the Civil Rights Commission in Texas, and the documents that they put together really helped in all the litigation, because they were really good. And when the Voting Rights Act was first proposed by Congress, the black organizations and the Civil Rights Commission nationally opposed Texas being covered by the act. And Richard stood up to them, and I think that was marvelous. And Tom Reston, who was the lobbyist, he was a young lawyer in Washington, and he was the lobbyist for the passage of extension of the Voting Rights Act to Texas. He later became the spokesman, I think, for the State Department, if I'm not mistaken. And Charlie, of course, was our witness in White versus Register. The story I'd like to tell about Charlie is how we set his fee. And he hates it when I do this, but we set his fee. He had just had a baby. And
Abby did.
Abby did. So two things that are interesting about this: it was $500. Can you imagine having a baby for $500 today? And for $500 today. Yeah, and that's what we paid him. We paid him for so he could bail his wife out of the hospital.
No. You didn't make a penny off of that thing.
Yeah. And Eddie Dar, who really was the lawyer in White versus Register, was that Shannix, made an argument before the Supreme Court in White versus Register, and really I think that's what carried it for us. He made an excellent argument. One of the things that I think I'd like to say is that White versus Register and the Section 5 and voting extension of the Voting Rights Act to Texas are really essentially the same thing. The extension of the Voting Rights Act to Texas used the evidence and the decision that came out of White versus Register, and much of White versus Register, the secondary litigation that we had in all of the other large cities in Texas, they were actually settled by using Section 5. So it's really hard to distinguish. There was a woman who's not here, unfortunately, Pat Villarreal, who from San Antonio, and she was the committee in 65, in 75, I should say, she was the committee counsel for Congressman Edwards, who was the head of the subcommittee on civil rights in Congress. And I think that she, more than anybody, sold the whole idea of the Voting Rights Act to cover Texas. And she's never gotten credit that she really deserves there. And she knows, I mean, she knows where the bodies are buried and how it actually came down and how they convinced enough of the congressman to go along with it. In any event, I wish she was here. Henry Floodis, I always say was a great, is a great or a good expert, because he never flinches once he gives an opinion, he sticks to it. And even when the lawyer on the other side convinces me that they're right, we would stick to it. And obviously Jose and Joaquin. I just want to make a couple points about why we don't have the Voting Rights Act now, and why Section 5 of the Voting Rights Act, and why it's important. Dr. Susan Corbel went with me a couple times over to Beaumont. I was doing some work for the Beaumont Independent School District. The Beaumont Independent School District is primarily, the students are almost all black, and the blacks had finally gotten control of the school board. Finally gotten control of the school board. And but there was this awful, they're the kind of people that were here when I first came in 1970, but they were just awful. And it was the same way. All the blacks sat on one side of the room and all the whites sat on the other, and the whites all looked like they're total trailer trash. Really, I mean, that's what it was. What we were trying to do is we were trying to create a plan that would continue the blacks in control of the Beaumont Independent School District. And we got that plan. We got that plan passed. And the Voting Rights Act was used to invalidate an earlier plan that they had passed, Section 5 of the Voting Rights Act. And then we lost Section 5 of the Voting Rights Act. And the first thing that happened after we lost Section 5 of the Voting Rights Act was the Texas Education Agency came in and threw all the black councilmen out, all the black school board members out, and put white school board members in. And they took the Texas Education Agency took over the control of the school board, and because they've got that power, but they never were able to exercise it when Section 5 of the Voting Rights Act existed, because we could easily show that this exactly is what's going to happen. So in Beaumont, we lost the whole thing as a result of Section 5 going away. And Galveston. In Galveston, we had 20 years ago, 20 years ago actually, we created a plan where Galveston was elected 2 and sometimes 3 black JPs. And we were able to keep that, and then comes the doing away with the Voting Rights Act, and so they did away with the voting. We did away with them again, and we've litigated that case, and we're 3 years or 4 years still. The judge hasn't decided, and now only one black gets elected to the as a JP, and it's kind of it's a bad situation there too. The other thing that's happening because we've lost Section 5 is there are a lot of jurisdictions that are going to mixed plans. In other words, there are some single-member districts and then several at-large elections rather than all being single-member districts. And that's important because, for the most part, the at-large people will be elected will be Anglos, and the people elected from the districts will be minorities. And if you put the Anglos that are elected from Anglo districts together with the at-large, then they outvote the the minority population. And that's going on over in the Houston Community College District, and a number of other places in Texas. It's a very bad situation, and there's no way we can stop it because we don't have Section 5. I guess the other thing I wanted to say was, why did we lose Section 5? We lost Section 5 because the Supreme Court didn't think that there was still election discrimination. And if you look at what the data is, in the last 15 years, which is essentially from 2000 until now, there have been 104 findings of racially polarized voting in Texas. 104. And the Department of Justice has sent 1,168 federal election observers to look at our election. 1,168. I mean, I was so surprised by that. I thought maybe we had a couple hundred. But, in this last redistricting case, Judge Rodriguez, who was a federal judge, he had formerly been appointed to the Texas Supreme Court. And they went around to all of the big cities in Texas and swore him in each time to make sure that all the Republicans understood that he was going to be their candidate for the Supreme Court.
Their boy.
Yeah, he was. Yeah, exactly. He was. Exactly. And so he took the Supreme Court. And so up comes the election. A year and a half later, he's bought a house in Austin. Up comes the election, and he loses in the Republican primary 244 of the 254 counties in Texas. He only carried 10 counties out of 254. And the guy that beat him was not just an ordinary guy. He was the guy that handled the white discrimination case against the University of Texas. He was an absolute abject racist. The Republicans were even embarrassed by him. So it goes a long ways. So in any event, he's now on the federal court because he got thrown off the Texas Supreme Court. And in the last piece of litigation that we were involved in dealing with the state legislative districts, he calls the state solicitor to the podium, and he says, "Didn't I ask you to get back to us on the state's position on whether or not racially polarized voting exists in Texas?" And so the solicitor freezes, and the solicitor says, "Okay, and so the solicitor calls up one of the younger lawyers. So the younger lawyer says this: "The state's position on whether racially polarized voting exists in the state as a factual matter, it has been established in almost every area of the state, except Nueces and Clayburgh." He never did explain why that was, which is probably the worst places. And he says, Anglo voters tend to prefer different candidates than African American and Latino voters. That's what the expert analysis has shown, and I don't think there's any dispute about that. And that's all because all of these lawsuits have been successful. I've handled the fewest number, I think, about Jose and Rolando Rios and everybody else who have handled those lawsuits. But in addition to there have been 120 findings of this racially polarized voting since 1995. And when we looked at the original extension of the Voting Rights Act to cover Texas, we were looking at 15 cases. And now we've got all of these cases. Final thing I wanted to say was, before all this litigation started in Section 5, Texas had 1,200 school districts at that time, and we have about 1,500 cities, 254 counties. But in any event, all of the city councils and all the school boards were elected at large. Not a single one in the state was elected. Now, almost 90% of our population lives in districts, in election districts where single-member districts are elected, and the numbers have really worked out. So, in any event, that's what I wanted to say. Is I really think that the Voting Rights Act continues to be needed in Texas. The issue of racially polarized voting now, I think, is after the states gave it away, I think it totally. And the other thing I probably want to say is that, talk about judges. When Jose and the other lawyers presented the lawsuit before the district court for the District of Columbia on voter ID and on state redistricting, the judges, 2 of them on state redistricting, 2 of them were Republican judges, and one of them was a Mormon, and really conservative judge he was, and all of them were just aghast at what Texas had done during the redistricting, and I think, and they were the judge that was the head of the panel. She was she was needling the lawyers for the state, that they weren't embarrassed by what their clients had done, and that was because they had put all this stuff down in tweets and in emails. So we had gotten it. So they had given it totally away. But they just had no shame. But if we were before judges down here, with the exception of 1 or 2, I think they wouldn't have even registered, you say, right? I mean, they wouldn't have, they would just accept that this stuff is going on. If we could try all our cases in D.C., we wouldn't need Section 5 of the voting rights act. Anyway, that's, I don't want to say any more.
Can I just,
End note from Henry or footnote?
yeah, as a footnote, just to show you the rich history of the difficulty Texas has being fair in building election structures. Between 1975 and 2013, Texas had 198 Section 5 objections, or 18.4% of all of them across every state covered under Section 5. I mean, we lead, we're good. We're very good.
We take no back seat.
We take no back seat in discriminatory behavior to any state in the union. We are good. That's what we do.
The other thing on that, Henry, is after the Section 5 was extended to Texas, for the first year, in 1 year, Texas had more objections than any of the other states that were covered by the Voting Rights Act. In 1 year, they had been covered by 10 years, and 1 year they got more in Texas than in Texas.
We'll turn to questions in just a minute, but I wanted to add a few more things because we haven't covered them, and not every problem is solved by a voting rights case, even if you got all the heavyweights and the best experts. Sometimes you lose when you win. And by that, George, remember the case before the Supreme Court? Like, originally it was Lulac versus somebody, and then it became Maddox, and then it became Perry on the judges. Or judges subject to the Voting Rights Act. Can they be elected, or because they're all at large, right? And that case goes all the way up to the Supreme Court of the United States, and the Supreme Court says, you're all absolutely right, and sends it back to the state of Texas.
Well, it sent it back, but it sent it back to the state of Texas. Rolando Reyes handled that case. It sent it back to it remanded it, but the Supreme Court doesn't have any power to do anything. All they can do is issue an order. They don't have any marshals or anything else to enforce an order. So they have to send it back to the district court. So it made a finding that at-large elections, that the judges in Texas are covered by Section 2 of the Voting Rights Act. Sent it back to the district court. The Fifth Circuit grabbed it on the way back, put it in en banc, and it reversed the Supreme Court. And then the Supreme Court wouldn't take the case anymore. So that's, you're right, that's exactly right.
So sometimes you win and you lose, not only the decision, but the money. Now, I want to talk about the money. Because, you know, as Vilma can tell you, and Joaquin and other people, you know, MALDEF can't fund everything. Even though in some, and Al, you call it, you know, in some of the voting rights cases, the attorneys are eligible to get the money back, whether it's settled or by judgment, and including the experts, the costs, you know, so you can get your money back, but it is discretionary on the judge. If you bill, say, well, it costs us $3 million to bring this case all the way to you, the judge can say, well, we'll give you $1. Now, I'll just give you one example, because I am a lawyer, and I do occasionally do a case or two. It's got nothing to do with voting rights, but the Chicano Studies case in Arizona. I was the last lead attorney and forced it into the settlement. And the federal judge who came in to enforce the settlement and award attorney's fees gave us $1. Now, fortunately, I'd say by way of introduction of the theme, as well as to say I have another hat while I'm here. I'm the director of the Greater Dallas Legal and Community Development Foundation. Been doing that since 1986, and one of the main jobs of this little foundation is to fund these guys. Now, we don't have the MALDEF money, and we certainly don't have the Ford Foundation or the Bill and Melinda Gates Foundation money. But what little money we have, we put it basically in the voting rights and some community development activity. So on the Chicano side, this is it. Now, there's one other group, and that's the Southwest Voter. Now, but Willie ran out of money. If any of you know about Southwest Voter, you know they're chronically underfunded and have terrible fundraising abilities or disabilities, so they're always behind. And so Willie, at one time, the Greater Dallas and Southwest Voter, we funded about 18 or 20 cases in the state of Texas to carry this on. Now, my job is not only to try cases. The reason I did the Arizona was because I couldn't find an attorney to take the case. Okay? So I had to go do it myself. Now, raising money is also the same problem, and that's a problem that we don't address here. This costs a lot of money. As Henry told you, right now, I guess about $3 million. You got spare change? and again, it came up in another forum, and then, of course, Uriega told us about economics. If you're going to have a quinceañera, man, we'll spend $25,000, $30,000, a small wedding. If we're going to go a Cowboy game, we'll spend $1,000. Sin pedo. You ask someone, how about $10 so we can send the lawyers to Washington to fight a case? What? We simply do not have the money for these kinds of cases. Now, we'll go to bingos, but you can't do this with tamale sales and barbecue chicken plates. It just can't be done. Maybe one local case. Now, let's talk about the local cases, because you win and you lose. Now, these are just all Raza Unida cases. I'm also involved with that. Armando Villarreal, Kingsville, Texas. First guy to run against the city council in Kingsville, wins. And then here comes the tricks. The rules determine the outcome. First thing, impound the ballots, voter fraud. Well, here comes the Rangers. They take the ballot boxes usually to a favorite bank that they have a relationship with, and they're in control of the ballot boxes. Then they bring them, and the unit that provides the election impanels a group to count the ballots again. Now, if you've got the moxie and you already know about this, you'll get poll watchers to go watch them count the ballots again. And even if you're there, they'll say, oh, see this mark here, this person, we're not going to count this ballot, or count it against you. They have absolute discretion to decide which ballots to count and which ones not to count. So Armando Villarreal lost. Ran again, won again, recount again. This time we had to go to an election contest. This is after the impoundment of the ballots and so on. Even if you win the recount, they can file an election contest and you got to go to court, an actual trial. So now we got big money, got to have lawyers again. And you run out of money. Severita Lara, that already happened to Villarreal and Kingsville. Severita Lara, first Chicana to win as county judge in the state of Texas, before Alicia Chacon in El Paso. She gets impounded. She loses by one vote. Now, she had won the election by several, but then at the impound, they changed the votes. They threw a bunch out. She loses by one vote. So she brings lawsuit. Now, in order to bring a lawsuit in an election contest, if you're the loser, in this case she was running for mayor, there's no salary in Cristal for a mayor, but if you're a county judge or you're a commissioner precinct or JP or state rep where there's a salary, you're required to post a supersedious bond of 3 to 5 times the amount of the salary for the term. So if you're a county commissioner earning $40,000, let's say in LaSalle County, times 4, that's $120,000, times 5, that's a little over $500,000. Now, who in the community, other than Villegas, is going to sign over the property to supersedious bond? So if you can't post the bond, you're not qualified to go ahead and put the stand in, because if you lose, you got to reimburse the person that won that can't take the job and get the salary. Okay? These are just rules. Now, Severita did the tamale sales, the cakewalks, you name it. Short of doing the dance on the poner a dollar a quinceañera, she finally got tired of asking the community for money. Because it's true, most of these efforts prior to the Voting Rights Act and prior to MOLDEF and all these were locally funded. She got tired of asking the community and went on the radio and said, I can't ask you for any more money. I'm just going to have to quit the fight. And so she could have won. We had the proof that the impounding of the ballots and the counting were rigged. We had a person counting said I got paid to change the ballots. Criminal actions. She quit the fight because there was no more money. Okay? So sometimes you win and sometimes you lose. So the fundraising is very difficult, and there's not enough MOLDEFs and enough South Texas initiatives or ACLUs. I mean, ACLU, as far as I know, has never brought one in Texas. They did the Yakima case, where Joaquin was involved as well. So, but there's very few people that are involved in funding and fighting these kinds of cases. So we do need all the help with it. Last thing, violence. Now, we haven't talked about this. There was mentioned by Ari Brenner in one of the panels about the beating of Modesto Rodriguez in Pearsall. That's Unida. Well, let me tell you about a few others. The young man that led the walkout in Cotula, Texas, as a message to him and the community, his father was found severed in 3 parts by the railroad tracks because supposedly he had been drunk, fell asleep on the railroad tracks, and the train ran over him. The autopsy, no alcohol in the blood. Never saw. Carlos Avila was the mayor of Crystal City after Juan Cornejo. That was the moderate coalition of Anglos and Mexican Americans, we would call them Hispanics today, who took over. And Carlos was an electrician, who specialized in air conditioning. At that time, it was the Anglos that had air conditioning. So when he started acting kind of Mexican-like, Luis Avila, his brother, suffered the beating of his life, almost died. He was in a coma for 30-some-odd days. Carlos never deviated anymore from what he had to do as mayor for the coalition that they had together. Nueces County, Ramsey Muñiz country, an important place. Because it was Ramsey Muñiz's area, he got some incredible turnout of vote. Incredible turnout of vote means a lot of votes. What happened immediately? The county attorney subpoenas, through an election challenge, subpoenas all kinds of Mexican voters to come and be cross-examined as to who they were and how they voted. Now, I don't know how well you know the Chicano culture and the Mexican culture, but a Mexican in Pearsall, in Cristal, in Robstown, in Cotula will tell you, yo soy honorable, anda chequea en la corte. They refer to the courthouse, the building, as the place of honor and fear. That you don't want to go to the courthouse. If you're going to the courthouse because you've been bad, it's not because you're going good to go register to vote. So when you're taken there to be deposed, the next year, Nueces County voter turnout, down. That's happened in Crystal City, for example. We were building schools, we passed the bond issue. Same thing. Alleged voter fraud, and that illegals had voted. Illegals had voted. Why? Well, in the Anglo community, look at the voter list or look at the voter cards. For some reason, not all of them, but a lot of the women used to, Anglo women, would say, I'm Mrs. Tom Jones. Mrs. Tom Jones. That's the way she registered in the voter card, and it was perfectly legitimate. I would register, for example, as Jose Angel Gutierrez. And my father was not a citizen, but let's assume that he would have been and had the same name. He would have registered in the same name. Because we don't have Junior. Okay? And we're not allowed to use the Spanish country's customs of adding the mother's last name. I would be Jose Angel Gutierrez Fuentes. Okay? So we don't use Junior, and we can't add the Fuentes. We're two Jose Angel Gutierrez. So that's where they latched on to the voter fraud and the illegals. Again, bringing in hundreds of people, and the opposing attorneys, because they're Chicanos that oppose. Luis Segura and Guadalupe Cortina. Okay? I'm pointing to Richard because part of the Civil Rights Commission, he was aware of these allegations. Those were the attorneys who brought in the people who had voted for the bond issue. Now, we won the case. We spent a lot of money defending, but it was 5 years later. Instead of building 13 new classrooms for a new building, we had to come down to 8. So sometimes you win and you lose. Questions? No questions, oh my goodness. Well, I'll let you warm up for a few minutes. You know, I'm gonna push the time limit because we're not doing the honors until 3:15, and so we got a few more minutes to do. But we were first, I think, no? Teresa?
Yeah, I just wanted to say that in the 1970s in Waco, we filed a lawsuit against the Waco Independent School District. George and Buddy back here were the attorneys that represented us, and I just want to take this opportunity on behalf of the Waco community, the Chicano community, to thank Molodef and these two guys.
And you mean Al Kaufman is who you mean?
Yeah.
Okay, and Reston is who, you wanna raise your hand? There we go, that's the other champion that got the extension to Texas for the Voting Rights Act. Emilio?
We have another kind of case here in Austin where we voted for the district-wide elections, and at the same time that Mexicans, because of city policies, are having to leave the center to the margins of the city and beyond. So it's kind of a cruel way of conceding something when they know it's not going to be long-lasting.
Yes?
Mr. Jose Arceo, Miguel's son. And, there was threats of violence to my father, but before my father started doing all this, he organized the VFW chapter. And he told my brother and my mother that, he was threatened. And he told them, great, don't touch my family, don't touch my community, but come after me if you want. But know that I know how to find you, and I know what to do, and I'll do it, and I'm not afraid to do it. After being a recon Marine in Vietnam in '68. So this is the change that happens, with veterans and such.
In Beeville, if I can, just before we go to Mr. Avena, in Beeville, the first Chicanos to win on the city council, the police chief comes and tells them, you show up to be sworn in and I'm going to kill you. This is their police chief.
Miguel was from Beeville.
And they were advised just not to come to be sworn in. They said, hell no, we're coming to be sworn in. So they did get a bunch of friends, to accompany them to City Hall.
I think it was after White Reed Register victory. Wasn't COPS part of the plaintiffs' communities organized for public service?
They were involved in the adoption of single-member districts in San Antonio and in Houston,
For the city?
for the cities. Yeah.
Okay, I think. I
They-
remember either Charlie or George telling me that after the single-member district for the city, San Antonio was won, that Andy Sarabia, the head of COPS, and it was a big party, big celebration, everything, came up to him and tapped him on the shoulder and said, now, tell me again why we wanted single-member districts. Do either of you remember that?
I do. I was a charter member of the foundation, the group that founded COPS, so knew them pretty well. And Andy was the only male president of COPS, I want to mention. But the COPS until mid-December 76, the election was in January 1777 that brought us the 10-1 plan. COPS thought that, I think they were misled on it, they thought they could control elections in at-large situations if they were cohesive. And we, George may or may not remember this, but we actually spoke to their vice presidents about what single-member districts mean. And then we, and I hope I'm not taking too much time here, but then we went to the courthouse, and we had placards that said District 1, District 2, District 3, District 4. And for the first time, there was this dawning, this realization, many COPS members were there. They would line up and get into their districts. And all of a sudden, the idea of what it meant to have neighborhood representation, though it'd be 74,000 people at that time, dawned on them. They then switched. They switched especially when they were attacked on the radio and television by Texans for Freedom, who said that these districts would tear the community apart. And COPS said, wait a minute, if they're saying that, maybe we're on the wrong side. But also they were persuaded that this was really a good thing for their community, and especially when 7 of the districts were, at that time, south of Hildebrand, a place in San Antonio that had had only 3 representatives for 25 years up to that point in time. So they said, hey, wait a minute. And of course, it did change things in terms of representation So that, I apologize for the length of the story, but that's the story.
I think one thing that's been missing here today is that we haven't discussed is we've talked about the victories and the establishment of MALDEF and fighting these wars and the good lawyering and the good expert witnessing and so forth and the courage of the community. It takes, by the way, a lot of courage to be a plaintiff. I mean, if I've seen, I don't know how many plaintiffs in different cases, and they are put through the ringer. Little old ladies, teenage, the two women in the voter ID case, the two teenage Latina girls who went up. You have to take off your hats to the plaintiffs who bring these cases and ask for help from MALDEF to do this. The thing that's missing, though, for me in all of this, and I think it's really, really important to warn you all, is that the Voting Rights Act is really on the verge and danger of being completely demolished. I suspect, and a couple of other scholars have been thinking about this all the way through, that we're very, very much afraid that they're going to start challenging the constitutionality of Section 2, which is all we have left, after they already gutted Section 5 in the Shelby County case. And we also are seeing beginning attacks on the 14th Amendment to the Constitution. And so the community has got to wake up, be aware, because I think that if you're not careful, we're going to have to be back and start the civil rights movement all over again, because that's the way the court seems to be going. Particularly the Roberts Court is extremely hostile to voting rights and civil rights in general.
Joaquin, if you want to step up and say something, just, let us know, 'cause that's the only way we're going to know that you want to say something about any point that's been being raised.
No, this has all been very fascinating for me and interesting. I'm glad that we're able, I've been able to get everybody together for this. We need to have more of these types of meetings so that we can really discuss strategy and where do we go from here. And unfortunately, where I have to go from here is out because I'm getting very tired.
May I ask you a question?
Yeah, just a quick question. Go ahead.
Why did you say that the Washington state law, VRA, was so bad?
I
What's bad about it?
I hear your question. What?
Why is the Washington state case and Voting Rights Act worse than the California Voting Rights Act?
It was done by a bunch of voting rights, so-called voting rights experts that didn't really know what they were doing. And they basically felt that they couldn't get anything passed through the state legislature because it was very Republican, and so therefore they had to bend over and make the state law very jurisdiction friendly. They did not include a mandatory attorney fee provision as the California law did. We initially told them that they should just take the language of the California Voting Rights Act and just adopt it to Washington State, and they didn't. They felt that that was sort of a losing proposition, and that no one would support it. And so, but more importantly, it was a very dangerous proposal because in order for you to file a lawsuit, you had to approach the jurisdiction and you had to show your racially polarized voting analysis prior to filing. And so, where are you going to get communities to spend anywhere between $5,000 to $50,000 to do a racially polarized voting study prior to and then turn over all your expert witness information? It was done by people that were not familiar with voting rights litigation, and for some reason I guess I was excluded from the process because they knew I would be jumping and hollering about it. So that's why I think it's very bad, the legislature.
Thank you.
Fortunately, it just died. It withered. It wasn't signed by the governor. It didn't get out of the Senate. So we're going to try again. I'm working with a couple of other people and we're trying to get a new bill before the state legislature.
Thank you. Gilma?
But I'm gonna have to leave now, so I'll see you folks. And George, great seeing you. Jose, Garza, great seeing you. Henry and Charlie, you bring back a lot of very positive messages.
Thank you.
I have a question about the people who are coming into the country that are fairly new. I'm on the board of Academia America, an organization that Mario Guzman founded in San Antonio. And we find that the participants, these are legal residents who are trying to get their citizenship. But they don't know our history as Mexican Americans. They don't know that what we've had to go through to get our political power. And I just want to know, ask rather, have you found that there's a lot of people like that are new to our country in terms of maybe just 10, 15 years, and don't realize the work that it has taken us to get that political power, and do they understand it? Especially since you've traveled, have you found that to be the case? Because I'm just thinking about the future.
You know, it's not just new people coming into the country, it's actually our youth today.
Well, that's
You know, we don't educate our children about the history in the schools. I find that the typical freshman coming into our university may have had one government class, maybe one government class. And they don't talk about civil rights or voting rights, and they're not even taught how to register to vote or how important that is. On one level, we have to have a huge educational process or system for not just people that are newly arrived, but just the whole general population, and particularly Latino children. They don't know the history of the Chicano struggle or fight for our civil rights at all.
I think part of it, though, is that they are being educated by what's happening in our midst, right?
Yeah.
Not just Donald Trump, but this whole fight over DOMA and the lawsuit. MALDEF and Nina Perales were allowed to intervene by the Fifth Circuit. They were denied intervention. They represented three women, undocumented women, who had United States citizen children, and were going to benefit from the executive order of the president. They were denied intervention at the district court. The judge in Brownsville that heard the case made statements before the lawsuit was even filed about how the president had overstepped his bounds. Nobody filed a motion to recuse. I mean, I just don't understand that. Judges like that on the far right, and nobody is asking, he should be impeached.
Is that Jerry Smith?
You know, when you had a decent civil libertarian kind of jurist, Judge Justice, every year there would be bills filed to impeach him.